Okay, my name is Clark Adams. I'm with the again with the Division of Water Rights in the Applications Record section just upstairs. I've got my technological backup here, so I'm going to kind of follow with that. If you have any questions as we go along, please feel free to ask them. I might even answer them at some point. So let's go ahead and get going. I'm going to talk about the application process. And some of the stuff that Nate discussed, I'm going to kind of go over again in a little more detail. So, okay, well, sorry, that's just part of the slide. So, hopefully, like our technical guy in the back was hoping that wasn't crashing. So first of all, in the application process, let's talk about how we get a water right. Nate kind of talked about purchasing. There are ways you can apply for it. You can apply for it with an application appropriate, and that can be done in areas of the state that are open for appropriation. Not all areas of the state are open. Most of the state is closed at this time. You can file. Nate mentioned diligence claims. And that is a water right that has been in continuous use since before 1903 or 1935, depending on whether it's surface or underground. You can purchase a water right through if you purchase a piece of land that has existing rights on it that are being used. That's usually called by transferring by appurtenance, that the water right is already tied to the property. And there are cases where if you just want to buy a water right solely and then transfer it to another piece of property, you can just buy all or a portion of a water right. Purchasing a water right is a private transaction, and normally we would not get involved with that, and we really don't want to be involved with that. Usually our office is notified when the deeds have been recorded, and then we can update our records to reflect the new ownership. Some of the terms that we use often are what's a perfected water right, what's an unperfected water right. Perfected is used interchangeably with certificated, proved up on, decreed. When a water right has been through an adjudication process as a water user's claim and has been part of a proposed determination, then a water right could also be considered perfected. When a water user's claim has been issued through an election process, which is a proven up process, then also the water could be considered perfected. And then also an acceptably filed diligence claim would be considered an acceptably filed water right. An unperfected water right is basically just the opposite. You may have an approved application appropriate, but it's not been proved up on or certificated. One that proof is, or an application that proof has not been filed on or been not decreed. There are many areas of the state where water users' claims have been taken through an adjudication process, but they've never been published in a proposed determination presented to the court. In those cases, in most cases, they're just paper water. If there's a diligence claim that has not been accepted or there's problems with it, then it would not be considered a perfected water right. Okay. I'm going to talk yes?
Can there be a new diligence claim, or are they just old ones you're doing?
You can still file for diligence claims, and I'm going to go into that process here in a few minutes. So the question was, can we still have diligence claims? And yes, they are getting harder to file because one of the things you have to provide is evidence of continuous use. And in the past, they could bring people in that says, yeah, my grandfather put this spring to use, and I was there and witnessed it. If it was surface water, it's getting hard to find someone that was around in 1903 that has a good memory of what happened. We're going to talk about some of the common applications that we deal with. And I'm just going to talk about why you would file these types of applications and not the how. That's going to be discussed a little bit later. We'll talk about diligence claims. Let me get the right slide here. diligence claims, applications to appropriate, change applications, exchange applications, and temporary and fixed time. There are other applications that we deal with, and as one of the good bureaucratic agency, we're always coming up with more. So, okay, what does an application need to be acceptably complete? That's a term that we use often when something's been presented to us. So that if all the information is there and correct, then it would be considered acceptably complete, and then we can continue to process it. Nate kind of covered some of these, but each application we need to know who owns it, who the applicant is, the source of the water, where it's a well, a spring, or a stream, the flow or volume, the point of diversion, the existing or intended beneficial use. Usually we'll need an application map to identify where the beneficial use is occurring or will occur, and they also need the proper signatures. And everyone's favorite, there needs to be a filing fee. Okay, let's talk about the diligence rights. Sometimes people have called them in the past pioneer rights, because a lot of these rights were put to use prior to the state engineer's office even existing. And Nate went over these dates before, but for surface water, the important date is 1903. If you're going to file a diligence claim, you've got to show evidence that it's been in continuous use since at least 1903. And for underground rights, you've got to show this before 1935. And these dates represent when the state legislature created the process for applying for appropriated water for surface and underground water. And it was not retroactive, so it didn't go back and say, if you're using it, you've got to go back and file it, but they came up with a process for filing saying that you are using it, and that's what's diligence. And the important thing is to show that it's been in continuous use. A lot of times we'll have people come in and they'll have maybe a land patent, but there's never been any water developed on that property, so it doesn't really give them, unless the water's been in use, it doesn't count. And if you're really interested in it, it's under statutory procedures are found in 73.513. To file a diligence claim today, it has to be prepared by a Utah licensed land surveyor or engineer. And the claim has to provide the following. You need to show who the first person was that put it to use, and how the claimant today is the successor in interest of that, usually by showing a chain of title to the land going back to that original user. You have to know when the water was first put to use, and that's to tie back into those original dates, 1903 and then 1935. A flow measurement would need to be done. They would need to provide a map of the beneficial use showing where this use has been taking place, and then need to provide the evidence of continuous use. Whether some people have brought in family journals, history records of counties and cities, and it just can't be. There was one I reviewed. The gentleman said, "Well, I remember back in 1944 when I went up there with my grandfather, we used it, but he couldn't go past that, and so we couldn't process and accept that." And again, there is a filing fee associated with a diligence claim. Incomplete claims that are submitted to us may be returned for additional required information. After the claim is filed, it is advertised in the local paper where the claim is being filed, and this is to give public notice that someone is asserting diligence or a new claim in that area. If someone feels like establishing this claim is going to interfere with their existing rights, they can submit a protest. A protest on a diligence claim is a little bit different than a regular water right. to be an official protest on diligence claim has to be submitted to the district court where that land is, where that right is going to be established. The regional offices will do a field investigation of the diligence claim, and they'll prepare a report of diligence claim investigation as part of the record. And in that report, they will define the limitations of what they found. In some cases, people will be very generous in what they're claiming to what is actually on the ground. And really, diligence claims should only be filed when you can show there's clear evidence that it has been in continuous use and that you have a clear chain of title back to that. And for the exciting part of it, there's the diligence claim form. And all these forms that we'll talk about are available on our website, or you can come into our office and get it, or if you call, we can mail one to you. Yes?
What if a diligence claim has been filed on by someone else later on? In other words, both of them claim the water. Does the diligence claim preempt the filing?
The question was if someone files on the same source, the same use twice, and let me make sure I get your scenario correct. You have a diligence claim, and then someone already has some.
Claims they have a diligence claim now, but somebody's already filed on that same water.
One thing they'd have to show is who owns the property, who has legal access to it. Then most likely we're not going to make that determination. We can review the records, and it may end up having you may have to make a civil action in court to determine that. Okay, the next form or application that we deal with quite often is an application to appropriate. These are filed to create a new water right. In some areas of the state, it's still open. Basins are open where you can apply for a new water right. But like I said before, many are closed. Each water right area, and I should have put the map up, but Nate showed you the areas of the state. Some areas are closed to any new appropriations. Some are open to large ones. I'm not sure what the largest one is. I know there's one area that you can apply for a 120 acre pivot. And many are open for just small appropriations, which would be enough water for a home, a 1/4 acre of irrigation, and 10 head of livestock. Well, between a 1/4 and 1 acre of ground, depending on where you're at.
Is that on the website, which ones are open and which are closed?
Yes, there is actually a policy page for each area on the main page, and I think James is going to show that. On the main page, you go to it, there's a map down in the right-hand corner. You can click on that, and you can just click on the area that you're interested in, and it'll tell you exactly what the policies are for that. And I didn't repeat the question, but hopefully it made sense. Areas that are closed to appropriation, there are some circumstances where you can still file for a water right, and usually those are ones that are considered non-consumptive, like for hydropower, where you may not interfere with any other water rights. There are some areas that have geothermal resources, and you can apply for those through an application to appropriate. Okay. And there's that nice form again. They all look kind of similar, and a lot of the information is the same. But if you ever have any questions as you're trying to fill one out, or if you need just help walking through it, the staff in our office is always happy to help. Since many of the areas of the state are closed, change applications are one that we deal with quite often. And that usually what that entails is you've purchased a portion or all of a water right from an individual who's willing to sell a portion of theirs, and then you can file an application to move it to your property. It is subject to the policies from where the water right originates and where you want to go to, because you can't buy a water right in Logan and say I want to build a home in St. George with that water right. you can change, basically what you're doing is you're changing the aspect of the water right. You can move it to a new location, propose a new point of diversion, a well or a source on a spring or a river. You can change the place of use, the nature of use, how it's being used, the period of use and storage of the right. Change applications, you can, if you filed an application to appropriate and you said, well, that's not exactly what I wanted, you can still file a change application to amend that original application. But it does not, one thing it does not change the priority date. And it does not change the proof due date. That proof due date is always going to be running. Okay. All right. We also do a lot of exchange applications. Mostly those are done in conjunction with contracts that people may hold with the Conservancy District. Exchange applications are when you're going to relocate the point of diversion or the uses on a conditional basis, and that condition is usually that you have a contract. In most cases, what we deal with is the Weber Basin Water Conservancy District. People receive a contract through them for an amount of water, an acre foot or two, to build a home and uses somewhere within that in the Weber Basin drainage. And the Conservancy District's portion of their contract is that they will release that amount of water out of one of their storage facilities, like East Canyon Reservoir downstream, to compensate for the uses that are happening above there. If the parameters of the contract are not met or the conditions of approval are not met, then the exchange could be lapsed, and then the water would revert back to how it was originally used. Okay. We also do temporary applications. There are temporary applications to appropriate and temporary change applications. We don't do a lot of temporary applications to appropriate. When it says temporary in the application, that means it's good for 1 year or less. That application will expire after 1 year. They're usually used for short-term projects like mineral exploration, road construction, like that. In some areas of the state, temporary change applications are done quite extensively. I know in the Southwest region, there are times people don't have sufficient water for all the irrigation they want to do, so they lease water from another individual, and they file a temporary to bring up to the amount of water, the number of acres that they need. One important consideration is if you file a temporary change application on a water right, it cannot be used in both locations. And you've got to give something up to get something. And we've had issues in the past where people have leased their water and someone else has filed an application to use it on their farm for additional acreage, and the leaseor of the water continues to use it. So just, if you're going to lease it, you got to stop using it. Fixed time applications are usually they're for periods longer than 1 year. They can be filed in some cases they can appropriate water for a fixed amount of time, maybe up to 10 years. And those are for not short term, but projects that like mining, that the life of the mine may only be several years. One thing about temporary applications is they cannot be extended, they have to be refiled. Fixed time applications, if at the end of the period of appropriation, if you still need it, it can be extended or you can refile. They can be filed for all uses except domestic uses, but again, there have been exceptions for that. Okay. All right. Let's get into the application process itself.
Can I ask,
Yes.
you said on temporary applications, you can refile, you just can't extend it.
Correct. As with any good process, there's got to be a good flow chart. So this is our flow chart for the application process that we use. What we're going to do is we're going to break this up into 3 areas on how the application is processed. The first one is on the is that part, and kind of zoomed in on that. This is the filing and the review of the application. Let me go back. This is the initial filing, the notifying of the public, addressing any protests, and reviewing the proposal in its relationship with other water rights, and then having the regional office make its initial recommendation to the state engineer. Most of this portion of the process is heavily relies on our regional offices. Nate mentioned there are 7 regional offices, and it's usually, if you're going to be filing in a particular area, to work with that regional office on the application. Okay, to file an application, you can do it in person, you can do it by mail, or just. And if you have any questions as you're trying to fill it out, feel free to contact us. The applications have to be acceptably complete, and all the information needs to be there before they can be designated as officially filed. And there is a filing fee required. It's normally based on the amount of water that is involved. Usually the minimum amount is $150, and that's usually of 20 acre-feet of water or less. These filing fees can be paid by check or cash, and if you're doing it here in Salt Lake, you can do it by credit card. Our credit card ability has not been branched out to the regional offices yet. The date the application is originally filed establishes its initial priority. After it's filed, it's numbered, jacketed, scanned, and then placed on the division's website in a new filings list. The water right number identifies what drainage area is associated with, and again, this map shows the various regional offices and then the drainage areas. After the application has been accepted, the regional office will designate it for advertising. The advertising is important because it gives public notice of anyone who feels like this new application or change in water right may affect theirs.
Are there any newspapers that are still in business?
I think there's 2. No, yeah. The question was, are there any newspapers still in business? But yes, we deal with. I probably should get that. It's over 50 newspapers across the state.
And how many are in rural areas?
There are newspapers in every. We cover every county. We've had difficulties in the past where newspapers have gone, have folded up and closed their doors, and we've had to find other newspapers of general circulation in that same area. But we do try to publish where the water is going to be located. If it's a complex issue, we may publish it in more than one newspaper. Some small filings, temporary applications, or changes that are just proposing to move a water right less than 660 feet, we can waive advertising on those. So in some areas that are not controversial, where nobody cares what's happening or there's lots of water, then we may not advertise. In other areas where every drop is being fought over, we're definitely going to advertise. Even if an application is not advertised, it can still be protested, and it's still found on our division's new filing list on our website. And so the public record is there. We're not trying to hide anything. The advertising is done for 2 weeks with a 1-week interval in between. So it's advertised 2 times. At the end, after the second advertising, there is a 20-day protest period that's mandated by statute. And this is to give people time to decide whether or not they want to submit a protest. There's the 20 days is for informal proceedings, and that would be a protest through our office, or a 30-day formal proceeding, which if you wanted to submit a protest with the district court. Temporary filings are usually advertised at the discretion of the regional engineer based on their experience and knowledge of the area and the water rights, if there may be any impairment. After the advertising, we do receive what's called a proof of publication, and that's what you see up on the slide. And that's from the newspaper saying that it has been advertised, the public notice has been given, and we will not move forward on an application until we do receive that from the newspaper. And we get this question a lot, but your filing fee covers the advertising of the application, so we pay for that. Actually, you pay for it, but we pay the newspaper. If someone feels that a new filing would interfere with their existing rights, they are able to submit a protest. It's done by interested parties, and it's usually if you feel that their water right may be interfered with. But other issues such as property rights, title, or environmental concerns are sometimes raised. Protests should not be based on how well or how you like or dislike your neighbor. A protest should be related to how the protestant will be affected by the application, if the application is approved, and not the applicant's questionable parentage or genealogy. It really gets down to the statutory requirements for approval, and that's what should be addressed in a protest and for that discussion. General concerns about water tables dropping, urbanization encroaching out into rural areas, or the need for a water management plan should be addressed as a general letter to the division as a concern, and not as a specific protest. If it's general in nature, send a letter to Kent Jones. He loves to get those. And if you want, I can give you his address. We've had letters come in and say, I want to protest any new filings in an entire area. We usually will not accept those. A protest has to be specific to a water right that is being filed. So a protest must indicate, if someone's going to submit a protest, you've got to indicate the water right number or application that that are being protested. They have to be timely. They have to be within that 20-day period. And that is for you to establish legal standing. So if this were to go further in any court action, you would have the ability to receive notice and take action within the courts. You can submit a protest to any one of the regional offices or to the Salt Lake office here. One thing is, postmarks don't count. That the protest has to be in the office. That the protest must provide the name and address of each protesting party, and has to be signed by the protesting party or an authorized representative with power of attorney. And if we just get an anonymous protest letter, we may just put it on the file and it would not be considered a protest. Did I see a hand? Okay. It's also important that if you're submitting a protest to print your name. There are a lot of times the protests come in and it's not legible. If the name and address are not legible, the standing as a legal, as a protestant may be jeopardized. And unfortunately, there is a filing fee to filing a protest. It's $15 if you want to be listed as an official protestant. If a group of individuals sign a common letter and they only pay a $15 filing fee, then in most cases we will only list the first person on that list as the official protestant. If each one wants to be listed as a protestant, everybody would have to pay the $15 filing fee. The only exception to that would be a husband and wife could be considered one protestant. The protestants can indicate whether or not they'd like a hearing held, if they just want to give us additional information to consider as we review the application. And again, the only exception is protests on diligence claims. Those have to be submitted to the district court. You can submit, we've had letters of concern sent in, but the establishment of a diligence claim has to be done through, if a protest, it has to be done through the court. And we will be notified of that. If an application has been protested and people feel that they want to hold a hearing on that, that's something that we will accommodate. Generally, the hearings are held in the county seats where the water right is to be diverted and used. However, if there's not facilities available, we will accommodate other locations. Usually we try to visit each county several times a year, depending on the number of protests that we receive. And we try to try to do several hearings at once. So we try to make efficient use of the taxpayer dollars and time. Generally, the hearings are held to address issues brought up in protests, but they can also be used to gather information if the application is not clear or we just need additional information. If parties do want to hold a hearing, it's generally good to put that in a protest, and the determination whether a hearing will be held or not is usually at the discretion of the state engineer and after consulting with the regional engineer. If it's the same protest over and over again, most likely we would not hold a hearing to address the same issues. Normally these are informal hearings. We don't swear people in or have rules of evidence. And the assistant state engineer for applications and records and the regional office personnel are the hearing officers who direct the meetings. During the hearings, applicants are asked to provide the information and describe their filing and to speak in support of their application. Protestants can bring up their concerns and why it should be denied or whatever concerns they may have. Other interested parties can be involved, whether they witnesses, consulting engineers, they can present technical information or property title or whatever information they need to do to clarify. The hearings are recorded and they are placed on the water right file and it's available for everyone to listen to, and it's a great cure for insomnia if you ever have that problem. Again, hearings may be waived if there's sufficient information available and if parties indicate there's no hearing is needed. Once the hearing is completed, the responsibility for processing the application and reviewing what was brought up in the hearing falls back to the regional office and to perform a review of the file. And again, the information gathered in the hearings is part of the process for making a decision on the application. The next step, it would be review by the regional office. The regional engineer and his staff help in administrating the water rights in the particular regions of the state. In reviewing the applications, the regional office may do field examinations of the water rights where it's been used historically or where it's being proposed to be used. They'll review the policies of that area and review any scientific reports or hydrologic studies that are available. They may do water measurements and try to gather any of the information from any of the parties that if it's so required. If it is complicated, they may consult with staff of the Attorney General's office and the applications and records section, and to try to make the best decision possible. Any concerns brought up in protests are considered as in the decision-making process, and then they make a recommended decision to the state engineer. And with that, we go to the next section of our process chart. This is where a decision has been issued, and then the options after that. There are 3 potential recommended actions that we taken on an application, whether to be approved, rejected, or deferred. If it is approved, then an initial draft order of the action is prepared for a final review by the applications records section, and the approval can only be considered if it meets statutory criteria. If the application does not meet the statutory criteria, it could be recommended for rejection. And then again, initial order is drafted and to be reviewed by the applications and records section. If it's deferred, that is usually when additional information is required, or sometimes the parties want to negotiate a settlement to make sure all parties are happy with the decision, or if additional studies are needed for to decide whether or not an application could be approved. Once the regional office has made their recommendation, the application would be designated again for review by the applications and records section. I'm not going to go into this too much because I think it's going to be covered in a later presentation. But by statute, there are criteria that we have to follow, or an application has to meet, in order to be approved. Most of those are found in 73-3-8, and you can look at those if. Okay. In the application record section, once it's designated for us, we'll review the initial order as what is or the recommendation by the regional engineer. We review it for completeness, that it's accurate, that if there's any description of math, that the math works, and that it's consistent with statutes and division practices and policies. Again, if it's complex, we can bring in staff of the Attorney General's office, and we may recommend we can contact the regional office for any changes in language or additional clarifications. Any corrections that would then be made, and then the final draft is submitted to the state engineer. And he will review the final draft, and if he has any questions or requires any more information or changes made to the order, he will move it back to the applications record section to make any adjustments to the order, and we can consult with the regional office to make any changes. If the final order is signed by the state engineer, copies are sent to all the involved parties, the applicants, the protestants, on the same day that it is signed. If the application is approved, that is that's the applicant's authorization to go ahead and start developing the water under any limitations that may be in the order. If it's rejected, then the application is terminated. The applicant cannot take any steps to put that water to use. All the orders are again are scanned and attached to the individual water right number and are available on our website. After an order has been issued, you can, if you have any regrets on what the decision comes out to be, you can ask for a reconsideration, saying that the state engineer didn't look at all the possibilities, or we didn't look at it correctly. I think this where it gets important on the legal standing with being a timely protestant. If you're timely, you have a right to reconsider, ask for reconsideration on an application. If you're not, you lose that legal standing. So if the applicant doesn't like how the decision is issued, or the protestants don't like it, they can request for a reconsideration within 20 days of the order being, that the order was signed. If granted, if the reconsideration, if we receive a reconsideration and if we grant it, the order, the status of the application goes back to the previous status. If in most cases this would be unapproved. If it is denied, if the issues brought up in the reconsideration are denied, then the application goes forward. And basically, it's denied if you don't hear back from us. Let's make sure I'm covering everything. If it is accepted, we'll issue a new order after it's reviewed, and then it opens for reconsideration again on that new amended order. If you don't like anything that's happening, you can always they can be appealed straight to the district court. When an application is approved, the last paragraph talks about the 20-day period and the 30-day period. The 20-day period is the reconsideration period to our office. The 30-day period is an appeal period to the district court. Again, it has to be timely, and a lot of times this is called a de novo review. De novo just means from the beginning. And always the 20 days and 30 days is from the date the order was signed.
If they do ask for reconsideration, does the 30 days start at the end of that reconsideration, or back to the date of the order, so they have 10 more days?
Sorry. If they ask for reconsideration on the 20 days and it is denied, they have 30 days from the date it was denied.
But you don't know if it's denied. You don't do anything.
You count that 20 days, because when we receive a request for reconsideration, we have 20 days from that date to
Day 21 you can file.
on day 20 if you haven't heard back from us. And if I'm teaching any false doctrine, please let me know. No one is looking nervous over there.
No, Clark, I think you're exactly right. If say we take no action after that 20 days, it's automatically denied. And then that 30-day time period would start from that point. If we grant a reconsideration period, then that 30-day period is put on hold until such time as the state engineer then makes a decision on the reconsideration, takes additional action, and then they will have, that 30-day period would start after that. So.
Okay, thank you. With a review by the court, a de novo review, they will start from the beginning. They will review the application, the whole application process, and that is done by the court. A de novo review is not a process to find fault in the state engineer's decision, but is a process or how the decision came to be. But it's a new look at the application and how it applies with statutes and policies. And this review is get done by the court rather than the state engineer's office. The district court can uphold the original order. they can deny the appeal or deny the order. They can amend the order. And in some cases, they have remanded that order back to the state engineer and tell us to try again. And if parties do not like the decision issued by the district court through a de novo review, they can still appeal it to the Utah State Supreme Court. And there are some famous decisions that have happened because of that. All right. Okay. We'll look at the last section of the application process. And this is the approving, the using, and the proofing of a water right. If the application is approved, it is, we've talked about, it's put on the new filings list, and it's available for everyone to look at, and the interested parties receive a copy of the approval order. Approval of an application is based on part that the applicant has the means and the intention to pursue timely development of a water project. If it's otherwise, it could be considered speculation, and by statute, a speculative application cannot be approved. The approval order will give a date that the application or the development should be done by. That's called a proof due date. Normally, it's about 5 years after it's approved to give you time to develop and put the water to use. If you forget about your filing, as long as you keep your address current with us, we will send you a reminder notice. 60 days before the end of that proof due date, we'll send you a letter saying, if you're using the water, it's all done, file proof. If you need more time, file an extension. Then an extension can be filed to request additional time, but you also need to show that you've been diligent in trying to pursue it. If you just forgot about it, maybe you didn't really need it right then, that may not be reason enough to grant an extension. If neither proof nor extension is requested by the proof due date, the application will lapse. Within 2 weeks after that proof due date, we will send what's called a final notice of lapsing, saying this application is lapsed. And the legislature, being kind-hearted as they are, they've initiated that you can, within 60 days of that final notice of lapsing, you can request for the water right to be reinstated if you either file proof or file an extension. If that 60 days expires, that application is considered permanently lapsed. And this will happen even if the water is being used, an application can lapse. It's important that the owners of a water right keep their address current with our office, because that is the means by which we'll communicate with you. If you've purchased a water right and there's an application running on it, you may want to make sure that the ownership is updated, so you'll get any notices that are being sent out on a water right. It is in statute that says it is the owner's responsibility with our office to keep their address current. There's approximately 200,000 files just one floor above us of water rights, and I don't know, probably over 1 million different owners. So it's hard for us to track down addresses for that many people. Okay, we talked a little bit about extension. Let me talk a little more in detail about them. If your proposal has been delayed or need additional time, you can file for an extension. Request forms are available on our website. We can mail them to you, or you can come in and get them. There's a couple of important dates. When an application has been approved, you have approximately 14 years, or we track what's called a 14-year period. If you file an extension between the 0 year and 14 years, there's a $50 filing fee to to do that. As long as you're showing diligence in completing it, say in the first 5 years you're able to get a well drilled and a home built, but you need more time to put in stock water facilities and irrigation, you can request extensions. Economic hardship is a common request for a reason for an extension. But if an application that's been approved for over 14 years and has not been perfected, we have to re-advertise it by statute. And so there's a $150 filing fee for each extension after 14 years. If an application is that old and you haven't done a lot, it will be critically reviewed and may not be extended. The request for an extension is reviewed by the regional office staff, and a recommended action is made to the state engineer. The statute on extension states that construction of the works and the application of water to the beneficial use shall be diligently prosecuted to completion. So you need to be working on getting that done, and in most cases we're pretty lenient on the reasons. Some of the diligence that can be shown is that you've shown that the well has been drilled, a home has been built, or you may be struggling getting the proper permits through whatever agency you need to get. And the extension that is filed, it should be specific on what has been done and what is yet to be done in order to be completed. If the request is granted, you'll be usually given another 5 years to complete your project. And if the application is denied, the application is lapsed. But the order either approving or denying an extension is also open for reconsideration, as we talked about a few minutes ago. We've talked a lot about proof of beneficial use, and I'm going to kind of go into this a little more detail. What is proof of beneficial use? When a project is complete, whatever you proposed is done, you drilled the well, you built your home, you've got your livestock and your landscaping in place, and you're ready to file proof. Proof is where you are testing that what has been proposed is now complete. The proof form is required that you have a surveyed location of the point of diversion and the uses of the water. They'll put together a map showing the location of the point of diversion and all the uses. A flow measurement will have to be done from the source, and it'll have to be signed by all the applicants of record and by whoever prepared it, attesting that it is correct and truthful, and all the documents and information are correct to the best of their knowledge. By statute, the proof has to be submitted by a licensed land surveyor or engineer that is licensed in the state of Utah, and they are responsible for the accuracy depicting the completed project. The proof is then could be field examined by the regional offices. If there are errors or significant corrections that need to be made, it would be sent back to the engineer for those corrections. If the proposed project is significantly different than what was proposed, we may require an amending change application to be filed to correct those uses. Some examples of that would be you proposed a well in one location and you ended up drilling it a mile away, or the uses that you proposed, you decided on one home but you ended up building two. And in those cases, we would require a change application to be filed to amend the original application. The only difference in that, there would not be a proof due date established on that amending change application. If the proof is acceptable, then a draft certificate is prepared and sent to the regional office send that to the applications records section. If the proof is not acceptable, there's no signatures, there's no real evidence of use to support what is submitted on the proof form and map, it can be rejected, and it would be rejected by an order of the state engineer. And if it's rejected, again, that action is subject to reconsideration, as we've talked earlier. If someone has filed proof prematurely, they could withdraw it but depending on when the proof due date is, if they file an extension after the proof has been filed, the priority date of the application could be reduced. Nate talked about it a little bit, but why do we make such a big deal about beneficial use? And page 1 of Utah water law says the beneficial use shall be the basis, the measure, and the limit of all water rights in the state. Basically, you're proving that you are using the water that you made application to, and is done by a licensed land surveyor and engineer. Several years ago, the legislature amended some of the statute, and they developed a path for individuals to prepare their own proof. It's called an affidavit of beneficial use, or we just call it a proof affidavit. In this case, it is prepared by the applicant themselves. And let me just go over that a little bit. This came into effect in May of 2009, and it's limited to for a small domestic filing. That would be water associated with a home, irrigation of no more than 1/4 of an acre, and livestock stock watering of no more than 10 large animals. The water use must be associated with the residence, but the residence does not need to be part of the water right. The home could be receiving its water from a municipality. But any landscaping, irrigation, stock watering has to be associated with that residence. And it cannot include any other uses. No municipality, power, mining, dust control, commercial. It's only limited to those small applications with those limitations. If there are any other uses or the uses exceed those described, they would need to file a conventional proof. If the applicant wants to go through that, there are some required documents that need to be filled out, and the first one is that the affidavit of beneficial use form is filled out by the applicants and has to be signed by all the owners, and the signatures will need to be notarized. They have to submit a plat map or a subdivision plat map. Usually these are issued by these show the legal boundaries of the property, and they can usually be obtained through the county recorder's office. They need to submit a certificate of occupancy. These are usually issued by the city, county, or other municipality that issued the building permit for the home. If they're not available, we will accept a tax notice, as long as on the tax notice it includes that there's a home on that. And the last one is you need to provide a map of beneficial use. The map is prepared by the applicant. It needs to show the location of the well or the source of the water and the uses. And I'll show you an example of that in just a minute. If all these documents are not included, the application or the proof affidavit could be rejected. The proof affidavit form is available on our website, and there are step-by-step instructions on how to prepare it and what is required to be included. And the proof affidavit has to be submitted timely, like the other applications we discussed. Some of the frequently asked questions we get about an affidavit is if it is complete, yes, we will issue a certificate of beneficial use. You can hire a professional, a surveyor, an engineer to help you complete that. And our office can give you some guidance on how to prepare and what is required. But please don't ask us to fill it out for you, and please do not ask us to make the map for you. If you are unsure how to do it or need additional information, we would recommend that you contact a professional to help you either prepare the affidavit or a proof. Talked about the certificate of occupancy and the tax records. And a proof affidavit can be submitted on an application to appropriate, a change application, or an exchange application. Some filings are based on shares in an irrigation company. And if that is the fact, the irrigation company would have to be, they would also have to sign the affidavit. Here's just a quick example of an affidavit map. See if I can get this to work. It is working okay. It shows the well, and the well is tied. It's measured from 2 property corners. It shows the home. And it shows the irrigated area around there, and it's at less than 1/4 of an acre. And in this case, there's no stock watering facilities. And there's our affidavit form. Okay, the next step is either once a proof or an affidavit has been accepted and reviewed, we would issue, the regional office would prepare a draft certificate. The certificate is then reviewed by the applications record section for accuracy and completeness, and the final certificate is issued or given to the state engineer for his review and signature. If any amendments are needed, it's returned to the application record section or the regional office for any additional work. When it is signed by the state engineer, the certificate is sent to the applicant on the day of the signature and is scanned onto the water right record and available on the website. This is the final step in a lot of what people call perfecting the water right. So once the certificate is issued, it's considered a perfected water right. If the applicant accepts the certificate, it's optional, but it's recommended that you record that certificate in the county where the water right is located. And what this does, it ties that water right with the land that is associated with in the county records. If the applicant disagrees with the certificate, they can request a reconsideration on it, or appeal it straight to the district court also. So there's always something that if you have regrets about it. After a water right has been certificated, the next step is to use it and use it as described in the certificate and as what you proved up on. If any changes need to be made later in the future, if you decide you want a second home or another well, you would probably have to file a new application to include that, and you get to start the process all over again. If for some reason you decide not to use it, as we've talked about earlier, water rights can be subject to non-use if it's not used for a period of 7 years or more, and it could be subject to forfeiture, and someone could bring a legal action against you to have that water right forfeited. All right, I just threw this slide in. Well, it's not there. I don't know. Let me see if I can find it real quick. It's not there, sorry. That was my one humorous slide I had. Okay, well, I could show it to you. It's not as, I'll just maybe try to describe it to you. I don't even know where. It's a picture of me that's kind of embarrassing, taken about 20 years ago. I was out doing some field investigation and I got delayed. I got stuck in the mud. And as we're coming around a corner, the bottom of the road fell out and went up past the axles in mud. And I got to dig for several hours, try to get out, but we ended up having to call someone to come get us. One of the things I learned on that day is don't ever trust a Ford in the mud, and don't ever let your coworker bring a camera with you out in the field. But as you're going through the process, if you feel like we get a lot of inquiries about what is the status of my application. If you ever have any questions, feel free to give us a call. Some people feel it's been stuck in the regional office or on the state engineer's desk too long. He's probably using it to prop up his plants or something. But if you have any questions on where it is, or if there's a problem that can be that we can help you out with, we can help you walk through the process. But there are times that either through we are governed by statutes and policies that we have to determine whether we can move forward on an application, and there may be legal considerations whether or not we can approve an application. But if there's any question on where you're at, if I'm filing an application, where it is in the process, or what to do next, we're available to help you out, either through the regional offices or you can contact our public inquiry section here. That's all I have, and sorry about the last best slide, but any last questions? Yes?
How do you ensure there isn't an over allocation of water rights?
Well, we stopped caring about that a long time ago. The question was, how do we ensure there's not an over allocation of water rights? Most of the basins in the state are over appropriated, and we are trying to take action now to make sure that the existing rights are taken care of. Through studies, we try to see what the basins are capable of producing. The surface water is pretty easy to follow. The underground water, we try to do studies on see what the limitations of the aquifer will be, and try to limit the number of water rights based on that. Unfortunately, some of these basins were held open longer and more applications were filed, and they've exceeded what the aquifer can produce. And we're doing groundwater management plans in some areas to try to stabilize the aquifer to come to that safe yield so it won't just keep depleting. Some aquifers in the state there's a pretty direct correlation to the surface rights, and you'll see the water levels fluctuate depending on what year's dry years. Some areas there's not a lot of recharge coming in, and you'll see in one area I know that we have 70 years of data, and it's a continual downtrend, and that's an area there's a management plan in place to try to stabilize that and working with the water users. So seems like we're always playing catch up, but I know there's on paper in some areas are over appropriated. I think it's 400% in the Salt Lake Valley. About 400, it's over appropriated, but a lot of those are just paper filings. Okay. Any other? Thank you. Yes.
So when you do your public notices, are you posting all that on your website too? So there's the place that you can see all the public notices?
Yes, the question was, are we posting public notices on our website? And all advertising is put on there too. When an application is filed, it hits our new filings list, and you can look at the new filings list, and you can look at the advertising that has occurred in the last 30 days. And there are also some public notice websites that you can go on to and look at specific newspapers for the notice to water users. Most newspapers, I think, we publish on Thursdays, Wednesdays and Thursdays. So if you look in the public notice sections on that.
Well, I've seen the non-production well stuff, but I was more curious about the actual production, the chain, stuff like that.
It's all in the same place. James will probably show you some of that. If you're interested, you can pull there. It also linked to a map showing where in the state these filings have occurred in the last 7 or 30 days. Okay. Yes.
On your proof affidavit, you need the signature of an irrigation company if it is shared in an irrigation company. Or if the irrigation company doesn't sign it and/or it, then the irrigation company put conditions on their signature.
Question is on the proof affidavit, if it is required to be signed by an irrigation company, and if the company refuses or wants to put conditions on there, what do they do? Hopefully the irrigation company was aware of the application when it was first filed, because they should have signed the application. And after when the affidavit comes along, they can probably still put conditions on based on, because it's still their water right, and you would just be you'd be a shareholder. But hopefully you've had all that stuff worked out before the application was even filed.
It was.
Or there's been a change in the board and they had a change in heart. We would ask that you try to work that out, and if they, I know we've been a mediator sometimes in describing what has happened and why their signature is required.
Is there a process in place for filing for stormwater harvesting?
I'm sorry, I couldn't hear that last part.
Is there a process in place for filing stormwater runoff, stormwater harvesting?
Stormwater. The question is there a process in place to file on stormwater? The problem with filing for any water right is it usually goes downstream to somebody else who already has a water right. In areas, I think most areas of the state, all surface water is considered fully appropriated, unless you can show that it's excess water. So, and you can't make someone else above you waste water so you would get water.
Clark, recently the legislature has passed the right for people to be able to capture rainwater on a parcel of land, and they've set some really strict limitations, and Clark has talked why. Because, I mean, if everybody captured rainwater on property, that's where we get our stream flows. Okay, and that's where people's water rights are dependent. But in statute, it does tell us now that you can capture rainwater on a particular parcel of land, and you can capture up to 2,500 gallons of water from that rainwater harvesting and use it. And you do not have to have a water right, but you have to file a permit with the Division of Water Rights with the State Engineer's Office just saying you're doing it. They want to know where you're doing that. It also allows you to do 2 surface containers up to 100 gallons of storage water, and you don't have to file a permit with the State Engineer's Office. You can just capture that in those 100-gallon containers, up to 2 containers. So there are some provisions to do a little bit, but the legislature was very concerned about capturing too much of that water, because that water is what flows off and goes down to satisfy existing rights. But there is a small window that you can use some of that water.
Does that also apply to snow melt?
And the question was, does that also apply to snow melt? I mean, if you can capture that precipitation in the form of rain or snow, you can do that on a parcel of land and capture up to that amount of water.
Can the container be a pond?
No. The 2,500 gallons is an underground storage.
And it's set up as a covered storage underground. And I have had people come in and who have actually created an open pond. A vault, they put concrete walls on it, but it's open at the top, and have said that's how they're capturing their 2,500. So, but it is a formed container. It's something you've got to construct for that purpose.
Thank you. And that is something you can notify us about, and you can just go right on our website and do that. And until the legislature finds out, there's no filing fee for that. So, okay. Hope there's no legislators in here. Any other questions? Yes.
Where there is over allocation, let's say in drought conditions or so forth, and everybody's trying to use their full water right, how is that then curtailed or shared amongst all those who own water rights when there isn't actually enough water to move?
If it's surface water, Mother Nature kind of takes care of that itself because the water's not available. And if with underground, it's that the priority of the application, that's what comes into effect. One of the groundwater management plans they are doing down in southern Utah, it's a tiered reduction, and it's a 100 or 125 year plan. And if the groundwater does not start stabilizing, the first cuts will happen, and I think in 2030. Okay, and that is anybody that has a priority date earlier than it's about 1960 or 1954, and it's possible that they would not be able to divert water for their well. I'm hoping I'm retired by then and not around when that starts happening, but the plan is in place, and that tiered reduction that is on our website, and people can go in and look at those individual water rights and see which ones would be reduced if that plan is put into effect.
And for surface water, I'm thinking more of irrigation. Would it just be up to the local irrigation company or the water master to monitor?
And this is for surface water. Yes, most irrigation companies have either a ditch master or a commissioner that regulates whose turn it is, and most of those diversions are based on the priority date. I'm mostly familiar with down in southern Utah, where I spent the last 20 years. They have priority systems in the Beaver area starting in 1870, 1890, and 1900, or 1903. If the water is sufficient in the stream, if it's a certain CFS, then the 1903 can divert. If it drops below that, then they won't put water into the ditch for the 1890 priority. And then if it drops below the base flow for the primary rights, then everyone has a prorated shortage on whatever percentage of that flow is happening in the stream.
If they have a reservoir, haven't they often put it in a pool? So it's all the same?
Yes. The reservoir storage can offset that. But even on the Weber River, where they have some large storage, they'll still be governed by the priority date on who can divert. And the water managers watch that very carefully. Yes?
So the process you just went through is for a new water right with like a 2016 priority date?
Or a change application on an existing right that water may have been established in 1900. That's a change application.
And so this process, the only fee would be the $150 filing fee?
Through to our office. There may be fees associated with hiring a land surveyor and engineer, but there are no fees to file proof.
But where does it come into buying rights?
And that's how you first get it. And I won't bring our title people into it. They're sitting back there snickering. But if you need to purchase a water right, if you have a piece of property that there's no water associated with it, you find someone that's willing to sell you a water right, then you work out however much you're going to pay, and then it has to be done by title transfer is done by a recorded deed, and that's recorded in the county recorder, and then that deed is submitted to our office to update our records. Once that water right is in your name, we can take that portion of the water right that you purchased and prepare the necessary applications to try to transfer that to your property. And then
Does that get the priority date?
it gets the priority of the original application. If there are competing water rights in the same source, usually the only time we will look at the priority date of the change application is if there are multiple water rights competing for the same limited source. But the main priority date is of the water right. And that's one of the things that they're doing in some of these areas that are under groundwater management plans, is that some people are going out there and trying to buy up the early priority rights so they wouldn't be affected by these cuts. So I've gone way over my time. I've gone into your break. But thank you for your questions.